medical issues. He has the MS, as you're saying, arthritis, all of these chronic issues, but he is holding a conversation with someone he thinks is a minor, and then he goes to meet up with a minor with all these conditions. Right. You entered a plea of guilty on July 18th.
Yes.
According to your plea bargain, and you entered a plea of guilty to counts 1 and counts 3. According to your plea, punishment is to be assessed at a cap of 8 years in the prison. There's a $4,000 fine. The state opposes your application, and there's to be Chapter 62 compliance. Have both parties had a chance to review the PSI?
Yes, Your Honor.
Yes, Your Honor.
Any objections?
Judge, there's no objection to the PSI, but I think Mr. Lott, I know the court's familiar with his medical background. He's had a couple of seizures in the courtroom, so he gets nervous. He's asked me to communicate to the court that he would like to retract his statement to his PSI officer, where when asking about the instant offense, he made an excuse for his behavior. He accepts responsibility for his behavior. I know that because prior to the PSI, he and I have had that discussion. I think he gets nervous in settings, and I think it's the answer he gave is a reaction towards self-preservation with his family and his friends, and he's just very ashamed of his behavior. So I think the best we can say today, Judge, is regretfully, we don't want you to think he's making excuses, because that's certainly the way it reads. You see the full responsibility. His sister and his wife were present to testify on his behalf. He's just struggled with the shame and humiliation this has brought to his family.
All right. Any witnesses?
Yes, Your Honor. The first witness I have is Cecilia Jenkins Lott, his wife.
All right. Could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. State your name for the record.
My name is Cecilia Jenkins Lott.
All right. And if you may proceed.
Yeah, proceed. Ms. Lott, good morning. Thank you for coming down. You understand we're here today for the sentencing of Frankie Lott. Is that correct?
That's correct.
Would you explain your relationship to the judge with Frankie Lott?
I'm his wife. We've been married for 4 years.
And can you tell the judge how long you've known Mr. Lott prior to being married? How long you dated him?
We dated for 10 years prior to our marriage.
Did you grow up here in Bexar County?
No, I'm originally from Detroit. I've lived in San Antonio since 1984.
And can you tell the judge what your work background is, Cecilia?
I've been in the legal system working with attorneys since I was at age 18. I worked in litigation for over 30 years, and I've been in real estate for over 10 years.
And you're currently working in a law firm, is that correct?
Yes, I work at a real estate law firm.
Ms. Lott, can you give the judge some background? I know it's very long, but just kind of an overview of Frankie's medical conditions as he stands here today.
He was diagnosed with MS about 3 months after we got married in 2021. He's since subsequently been diagnosed with rheumatoid arthritis. He used to get shocks in his back and his neck because his lumbar and his cervical disc are degenerative.
And is he currently under medical care and medication?
He hasn't seen his general physician in 1.5 years since he lost his insurance. He sees a psychiatrist every week, sometimes twice a week, because they'll see an intern and a doctor. He is currently on medication. The psychiatrist just added a third, an antipsychotic. He's on depression medicine. He has patches for his pains in his back.
And prior to his arrest, Cecilia, can you tell the judge about his work background?
He actually worked for Criminal Justice Center. He worked there for a few years, leading up till January of 2024.
And you are certainly familiar with the charge that he's pled guilty to 2 counts to this court. Is that correct?
That's correct.
And you're not here today to make any excuses about that?
Oh, no. I think he did something stupid.
And has he indicated that to you?
Yes. And he's apologized profusely. And he just thinks he did something stupid.
You are aware that, I guess prior to this arrest, you really has no criminal history to speak of.
No.
He's been on bond for an extended period of time, is that correct?
Yes, since January of 2024.
Has he been on home arrest? Is that?
Yes, that is true.
And has he abided by all the conditions of his?
Oh, yes. I am the warden.
So you know that one of the decisions that we have agreed to leave up to the judge is whether she would give Frankie time in prison or a shot at community supervision. Do you think he's a good candidate for probation?
Oh, yes.
And can you tell the judge in your own words why he's a good candidate for probation?
Because he repents for what he did, and he has health issues that would make it impossible. He has health issues. He has repented. I believe that he would be okay at home. I've changed the phones. He's not allowed to have text messages or anything on his phone. I'm there. I monitor. I control the phone. I turn it off at night at bedtime. And he's homebound. He only leaves to go to his doctor's visits or to pick up prescriptions. And he's not allowed to do anything but be at home.
And obviously, I think your statements include that you would be supportive of him if he were placed on community supervision.
Oh, yes.
Is there anything else that you would like to tell the judge, Cecilia, that you would like her to take into consideration in making a decision about whether to give him probation or prison time?
He's actually a good guy. He was brought up to protect everyone. He's the oldest, so he looks after his brother and sister. He pseudo-adopted my adult daughter, who thinks he runs the world. He's a good guy. He just doesn't always think things through, and he sometimes does things that are stupid.
All right. Well, that's succinctly put. Thank you very much. And Your Honor, I'll pass the witness.
Thank you.
Just a few questions for you. Good morning. I just have a few questions for you, okay? You said that he was working in the criminal justice system up until January of 2024, correct?
Yes.
And in January of 2024 is right when he committed this criminal offense?
Right, and that's why he lost his job.
And I know I'm grateful for it, and you say, you control his phone and you control everything he does, but can you tell me in this court what he's done himself to take accountability for his actions? Because I appreciate it, but he is a grown adult as well, right? So he should be able to control his urges and his actions. So what have you seen him since leading to this case do in that regard?
What do you mean, like
Just make sure she can hear you.
outside of the home?
Or just
Well, he's very apologetic. He can't do anything or go anywhere. So, I mean, he knows that, and he feels bad for what he did and how it's affecting the entire family.
okay. No further questions for this witness, Your Honor.
May she be excused, Your Honor?
Yes. Thank you so much for coming to talk to me about it. Hi. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Do you need to take a breath? Okay. Just let me know when you're ready to proceed, okay?
Can I proceed, Your Honor?
Yes.
Dolores, if you would, ma'am, just take your time and speak into the microphone, state your full name for the record.
Dolores Brown.
Just a little louder.
Dolores Brown.
And can you tell us how you're related to Frankie Law?
He's my brother.
And would you describe your relationship?
Yes, we've always been close. Growing up, we've had fights. My mom always told us that to make sure we take care of one another because we're all we have. And I just love him so much. I have handled this situation that has occurred. It's very hard and difficult on a family, including my dad. We just lost my mother right before the incident happened. And that's why it's just difficult for me to stand this. My dad is deteriorating, and if my brother does go to prison, he's I know it's not gonna make it. It takes too many medications. Sorry.
You've done good. Let me just ask you a couple of questions. Just step back just a little bit. Okay, and just speak loud enough. Microphone here. You've certainly come to court every time we've been to court. Is that correct?
Yes, sir.
You understand exactly why we're in front of Judge Ford this morning.
Yes, sir.
She's got to make a determination whether to give Frankie prison time. There's a range in that we've limited, and there's certainly an application for supervision. Where I'd like to ask you if you could just, you've known obviously your brother and sister, but could you tell the judge some of the good qualities of Frankie that would make him a good candidate for probation?
Well, he's always protecting me, and he was with me. A lot of times he was better to me than my siblings. And all I can tell you, Your Honor, he regrets everything that he's done. Put shame on the family. Bringing shame to my dad, especially after just losing my mother.
Let me ask you, if he's granted probation, does he have the continued support of your family?
Yeah, absolutely, Your Honor.
You in Frankie's life every day?
And ever since this incident has been, and with his medical condition, I've been checking on him more, been making more contact, just trying to ease his mind, to let him know that, we all make mistakes and, and we all make mistakes and you have to own up to your responsibility and he does show the remorse for what he's done and the shame that he brought on his wife,
And if he is granted probation, will you remain in his life in a supportive capacity?
Your Honor, if you were to
Go ahead.
if you were to grant him probation, I stand here as a woman and I can guarantee that nothing like this will happen again. And if you can attach me to any type of documentation, because I'm not going to pressure the court, and I can guarantee that this will never happen again or anything else going forward. Thank you.
Go ahead.
And I'm seeing I'm scared of you myself, and what would you do?
All right, so this is what I want you to know, and all the witnesses to testify. Because people always are concerned, did I say the right thing? Did I say too much? Did I not say enough? But I want to let you know that you're giving me insight into your brother. I want you to know that there's nothing that any witnesses that have come before me that have said anything that has hurt him. All right.
Thank you, Judge.
All right. Do you have any questions?
No question.
All right. Thank you. State, are you still, you've heard testimony. Does your plea bargain still remain the same?
Yes, Your Honor.
All right. Yes, I'll hear you.
Judge, I think we've been to court numerous times, and I think the court can remember some of the health struggles that Mr. Lott has had, and I think the probation office did a good job of documenting his medical history from.
And just here's my question with regards to the medical history. Is this something that's brand new, or were these medical issues, a part of these medical issues, a part of when this incident occurred?
I think his MS symptoms started in COVID, although he was able to work through it, but I think his work was limited. Certainly his arthritis and back issues have outdate the origin of this case.
So he's had these conditions prior to the commission of this offense?
Yes, ma'am.
Okay. All right, you may proceed.
And so, Judge, I think the court's aware of it. Obviously, we put a date on it now. I can't tell you how long before the commission of the offense, but certainly the toll that it's taken on him has been significant. But he stands here today, Judge, as a 57-year-old man. I think there was one hiccup that I was reminded of reading in the PSI today, some selling alcohol to a minor when he worked in a restaurant, I guess, back in 2002. I hope the court won't hold that against him. I think other than that, he's lived his life being a good man, making good decisions, and certainly being a productive member of our community. And then he makes this mistake, Judge. It's a whopper. We get that.
All right, so here's my question. And counsel, maybe you can address this. Maybe you want your client to address this. So there's an online solicitation of a minor, and I am completely, I'm going to disregard the fact you want me to disregard, where he says that basically he was tricked. And I understand with online, I represented people before. I understand with online solicitation of a minor, you are sort of tricked in the fact that you think you're talking to a minor and you're not talking to a minor. So I understand the trickery in that portion, but this is what I want to address. So he's having this conversation with someone he believes to be a minor, and then he agrees to meet up with the minor. And he has all these medical conditions. No, that's what it says in the stipulation, that you actually agreed to meet up with the minor, and they arrested you, I believe, at the meet.
They arrested him on scene where the undercover cop and Mr. Lott agreed to meet.
So he has medical issues. He has the MS, as you're saying, arthritis, all of these chronic issues, but he is holding a conversation with someone he thinks is a minor, and then he goes to meet up with a minor with all these conditions.
Well, Judge, if you're asking us to make an excuse to him,
No, I mean, I'm just
guilty to it.
No, I understand he's pled guilty, but I'm trying to figure out the status of his medical issues.
Well, Judge, I don't know whether he was. You're asking me if you felt okay to meet up that day, or what the situation is. I can tell you that he's not feigning his medical issues.
Oh, no, I believe his medical issues are real, based upon the PSI and based upon issues that he's had when he's in the courtroom. I'm just trying to look at him globally so that I can make an appropriate decision on punishment in this case.
Well, I don't know exactly what the court's looking for. I certainly think he had medical issues that day. At that time during his life. Now, whether he felt okay to get into a car and go to a meeting, sounds like he did. So, but I can tell you that was how long ago? A year and a half ago, or some months ago. So I can tell you from his family and talking to him, his medical condition has deteriorated. So, and I think that's obvious to everybody. So hope that answers your question.
Yes, and that's what I want to,
Yeah.
for you to elaborate on that part.
Yeah. So, it has, Judge, I think you've seen it. I think these ladies, to the best of their ability, have articulated that. As his wife said, he's homebound.
Mhm.
He has nowhere to go. She's in charge of his phone. He's not going anywhere. He's lost his insurance, so he's at the mercy of the state. I think that if he were not taking this serious, then he would have violated the conditions of his bond, and it would have been a nuisance to the court a long time ago. So this mistake happens. He was afraid of losing his family. He's been able to maintain a relationship with his family, except time doesn't do anything with him except make his health worse. So I think medically, Judge, he's a good candidate for probation. I think, quite frankly, if he would go into the system, he's a burden to the system. That's not making an excuse for his behavior. But if the court wants to look at this situation globally, he's got a support group. He's going to have to register as a sex offender. His health is deteriorating. It's not going to get better. He has his wife lives at home with him. His sister's in his life every day. Brother, from his letter, has asked the court to not lose sight of one bad decision in a man's life, but perhaps to punish him for his goodness as well, because he's not a man with a criminal history, no drug or alcohol problem. I think it was a mistake that the court has seen a lot of men make. He made it, and as his family and the very strong women in his life have stated, they don't expect that he'll make another mistake. They just want the opportunity to care for him in these years of need.
The prosecutor lays out the state's concern. She notes that Lott retracted his PSI statement only today. She says, "Our concern is the same as what he told the cops. His goal was to go find this child and tell her she shouldn't be doing this and try to find her parents. He wasn't taking accountability then. He wasn't taking accountability when he did the PSI only today." She adds, "He had these health conditions. While they may have deteriorated, he had them. He drove a car. He went to meet this individual." The prosecutor is asking the judge to see through the last-minute change of heart. The defense argues that Lott is a good candidate for probation because he's remorseful and his health is deteriorating. But the judge has to balance that against the seriousness of the offense, online solicitation of a minor, and the fact that he actually showed up to meet the child.
And take care of them. And that's all we can offer the court.
All right, state.
The state, just looking at the PSI, Your Honor, our concern is, I know that they've retracted today what was on the PSI, but our concern is the same as what he told the cops to what he said here, is that his goal was to go find this child and tell her she shouldn't be doing this, and that, trying to find who her parents were so that he could tell them. And the state's concern is that he wasn't taking accountability then. He wasn't taking accountability when he did the PSI, only today when he's coming forward to the court, Your Honor, and that the excuses for the types of conversations that he was having with what he believed to be a 14-year-old girl on the internet, and then proceeding to meet up with that individual that he believed was a 14-year-old minor. That's just the state's concern, Your Honor. He had these health conditions. While they may have deteriorated, he had them. He drove a car. He went to meet this individual, Your Honor, and that's pretty much all the state has, Your Honor.
All right. All right, this is what the court is going to do. And the court is taking in consideration your lack of history. The court is taking in consideration your medical conditions. The court doesn't believe a sentence should be a death sentence unless it's called for the death penalty. And I say that if somebody is receiving the death penalty, all the other sentences, they're not supposed to be a death sentence. So I'm taking all of that in consideration. I'm taking your health in consideration. The court is going to find you guilty of counts 2 and counts 3. Counts 2 and counts 3 will run concurrently. There's to be Chapter 62 registration, and the court will sentence you to 2 years in each cause number. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Good luck to you. Is calling 2025 CR 002749 and 2025 CR 005428, State versus Brennan Smith. Can I have parties announce?
Andrew Harris, Salem, for the state.
And are you Mr. Smith?
Yes, right.
Counsel, have you received all discovery and did you review it with your client?
Yes, I have.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, Mr. Smith, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment? State, in cause number 49, are you proceeding on the indictment as presented?
Yes.
And in cause number 28, are you proceeding on the indictment as presented?
Yes.
Mr. Smith, did you review the documents entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand that you're charged with, in the cause number ending in 49, you're charged with collision involving an injury with a range of punishment, not more than 5 years in TDC or not more than 1 year in the county jail with a possible fine up to $5,000. In the cause number ending in 28, you're charged with evading arrest detention with the vehicle as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have plea bargains with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into these plea bargain agreements, you are giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so.
Do you believe he's currently competent and was legally sane at the time of the offenses?
I believe so.
Mr. Smith, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page in each of these cause numbers?
Yes, Your Honor.
According to the plea, punishments be assessed at 2 years in the prison. And the cause number ending in 28, there's a $2,000 fine. And the cause number ending in 49, there's to be restitution payable to Andrew James Branham and Catherine Ann Forshon. And the cases will run concurrently, and the state will take in consideration 2025 CC 001264 and 2025 CC 001262. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
It is.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
None.
And the cause number ending in 49, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
And the cause number ending in 28, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendants, please.
In each case, state offers exhibit 1 and attachments.
All right, and state, have you spoken with the complainant?
That I don't know.
All right, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, we are.
Anything you wish to say on behalf of your client?
Nothing.
All right. And the cause number ending in 49, the court will follow your agreement, sentence you to 2 years in the prison, give you credit for any time served. Take into consideration 2025 CC 001264, 2025 CC 001262. This will run concurrent with 2025 CR 005428. There's to be restitution, if any, to Andrew James Branham, Branham, and Catherine with a C, Anne with an E, Forchion, Forchion. Is there anything else with regards to sentencing under that cause number?
Nothing further.
And cause number ending in 28. As previously stated, the court is finding you guilty. The court will sentence you to 2 years in the prison, give you credit for any time served. There's a $2,000 fine. Time and money will run concurrently. This will run concurrent with 2025 CR 002749. Taking consideration 2025 CC 001262, 2025 CC 001264. And I forgot to ask, is there a need for the therapeutic community for him?
No.
Okay. Did you review, and each cause number, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And each of these cause numbers, because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
20. I just turned 23 days ago.
All right, so here's the thing. You've got yourself in a pickle, right? You're going to have to make better decisions. It's not the end of your life. It's the beginning of your life. If you come out and continue to behave the way you're currently behaving, you're going to find yourself living at somebody's Bexar County jail and at somebody's prison. You understand?
Yes.
When you get out, if you have a problem with sobriety, if prison has been a little bit harder than you think it is, and you need some help with mental health, if I'm still here, you can come back here and I'll find a placement for you, okay?
Thank you.
All right, good luck to you.
Judge Stephanie Boyd sentenced Frank Lott to 2 years in prison on each count, to run concurrently. She acknowledged his lack of criminal history and his medical conditions. She even said, a sentence shouldn't be a death sentence unless it's the death penalty. But she also rejected the defense's argument that his health issues made him a good candidate for probation. The judge's implicit question was devastating. If he was too sick for prison, how was he healthy enough to drive to meet what he thought was a 14-year-old girl? The defense tried to argue that his condition has deteriorated since the offense. But the judge noted that he had MS, arthritis, and back issues at the time, and none of them stopped him from getting into a car and showing up. The broader implication here is crucial. Medical conditions can be mitigating factors at sentencing, but they are not get-out-of-jail-free cards. If you are well enough to commit a crime, you are well enough to face consequences. Judge Boyd made clear that accountability isn't optional, even for a sick man. If you found this case as thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next session.